Can I go to a bar while carrying?
Can you go to a bar while carrying a firearm? In most states, the answer is no. Now, what is a bar? Many states define that in the statute. Just because an establishment serves alcohol does not make it necessarily a bar if they serve food as well. But alcohol and firearms don't mix, and that's how the legislature has determined that you can drink and you can carry a firearm. They just don't want you doing it at the same time. So if you choose to carry, you probably shouldn't be in a bar and you probably shouldn't be consuming alcohol. If you choose to do that, then it's probably best not to have your firearm on your side. And in most states, having a gun in a bar is a violation of law, and you can be arrested and charged for that. A lot of times I get asked, what is the Castle Doctrine? What is the Stand Your Ground law? And is it the same thing? And the answer is no. Stand Your Ground comes out of old common law, where you've always had the right to act in self-defense. But what the legislature had done in many states was impart a duty to retreat, in that before you could use deadly force, you had to use every reasonable means necessary to get away from the situation and not use the deadly force. Over time, as you can imagine, a lot of litigation has come up in cases where people are charged for unlawfully using self-defense. Not so much were they justified in shooting, but could they have reasonably gotten away? And the whole fight in the courtroom is over whether or not they could have gotten away or done a better job in defending themselves. And what has happened in many states, Florida included, the legislature has changed that to say you have a right to stand your ground, that you can stand your ground, you do not have to retreat, and you can meet force with force. So that issue of whether or not you could have gotten away is not an issue that's litigated in the courts. Sometimes running away is the best defense in a situation where you're confronted with violence, but sometimes it's not. And in Florida and many other states where stand your ground applies, all that law says is you don't have to run away. Castle Doctrine is a different concept. Castle Doctrine talks about your rights to use self-defense within your home specifically. Some states include your occupied vehicle. And what that statute talks about is in situations where you're using deadly force, you have to be in fear of death or great bodily harm. Under the Castle Doctrine, the law says if you're in your home lawfully and someone unlawfully enters your home, you can presume they're there to do you harm and cause death or great bodily harm. Therefore, that presumption of fear is implied under the Castle Doctrine, and you can use deadly force to defend yourself without actually being in fear or having to prove that in a court of law.